For pronouncement of judgment, item 31.
View of the above discussions, we are of the considered view that the order passed by the learned single judge does not warrant any interference. The present appeal is therefore dismissed, being devoid of merits.
With regards to item number 10, Lordship, we have filed an affidavit yesterday, Lordship. That has not come on record. That may be called forward.
I'm sorry. Who is for the other side?
I'm calling for the records, Lordship, not for adjournment.
Yeah, who is for the other side? Concept for the respondent has submitted that the counter affidavit has already been filed. However, the same is not like this is that they could take the same in this matter. On which date?
Day after tomorrow, Lordship.
Does this matter after 10 days to go date? So it's, yes.
May it please your lordship, my lord, as regard item number 9, my lord, matter may kindly be taken up, my lord, after a week, my lord. Today I have some personal, I already informed my learned attorney.
At the request of the learned concept of the
Respondent, my lord.
respondent.
I am for the income tax department law.
He is for the.
I am for the appellant law.
The concept of the respondent. Is for an adjournment list on so and so.
Much.
You convey the date for master of your.
Much. After a week. My lord. Deeply.
Wait, please, Lordship. Lordship, I beg to mention for item number 16 and 17.
16 and 17.
Lordship, the case is leading by Mr. D.K. Das. It's an advocate. He is out of station, Lordship.
Learned concept for the appellant. 16 and 17 in both the matters. Learned concept for the appellant.
May I pray for date, Lordship?
Has stated that arguing concept.
19,
Mr. DK class is not available.
19 February.
Matter may be adjourned based on so and so. Whatever. the
19 February.
Yes.
I beg to mention
Keep your
item 18 of today's daily list, Lordship.
Yeah.
I am led by senior counsel, Mr. B.C. Das, Lordship. He is unwell, so I am praying for an adjournment of this matter today, Lordship. And if
Learned-
possible, it may be
Learned
fixed on,
For the appellant that submitted that on account of non-availability of arguing counsel, Mr. B.C. Das. Matter may be adjourned. Response one, so
21st, Lordship.
whatever date.
Lies,
Yes.
May I please your lordship, I like to mention item number 29, my lord.
29.
Yes, my lord. Kindly pass over the matter for the day, my lord. Kindly pass over. I'm seeking adjournment, my lord. On
You know
behalf of.
the, anybody is from other side? In this item number 29. State council. Have you conveyed them?
Pardon, my lord.
Have you conveyed the opposite party?
No, my lord.
regarding adjournment?
In this matter, the youngest counsel, NJ Datta, is facing some personal difficulties. So he has instructed me to pray for adjournment, my lord.
Okay. Mr. So and so for Mr. Ranjay that submitted that Mr. Datta is not available on account of some personal difficulty. Therefore, the matter may be adjourned. Response so and so. Yes.
Obliged, my lord.
Lordship, I beg to mention item number 28, Lordship, with the
28.
with
Yeah.
the consent of other side, Lordship. We have taken concern from the
Consent of
other
the other
side.
party, yeah. Okay. And so, we made a place for adjournment. Adjournment, matter adjourned, response so and so. Yes.
Item 35, supplementary list.
Yes.
Lordship, we have issued an order, Lordship,
What order?
that they will continue to operate the stalls till the disposal of the.
There is that order.
All three. All three. Three stalls.
Mr. Ranjit Kumar Singh Chaudhary, council appearing for the railways, has informed this court that the senior divisional commissioner, commercial manager, North East Country Railway, Lumding, has passed an order dated 8th of February 2024, whereby the appellant is allowed to operate the stalls at Guwahati station during the pendency of the writ appeal. The communication produced by Mr. Chaudhary is taken on record. Communication dated 8th of February 2024, produced by Mr. Chaudhary is taken on record. Place this matter for final hearing. When?
Lordship, that's an early date, whenever the court permits.
When?
That will be after 2 weeks, Lordship.
2 weeks. Fix a date of after 2 weeks.
Very well.
Thank you.
Guwahati and Kamakya. 2 in Kamakya, 1 in Guwahati.
And Guwahati station. Kamakya and Guwahati.
Grateful.
Guwahati, 2 in Kamakya.
Yeah, we'll do that. Kamakya and Guwahati stations.
Grateful.
Thank you.
Daily list for orders item 1.
May I please your Lordship, may I invite your Lordship's attention to the office note dated 8/2/2024, Lordship.
2024.
Yes, Lordship. It appears, Lordship, the notices have returned unserved
Answer.
on lot of respondents, Lordship. I pray before your Lordship that, Lordship, I will move an appropriate application seeking permission of the court to make a paper publication because addresses there some difficulty. Lord.
Difficulty. Okay. As per the office report, notice issued to the respondent, all the respondents.
No, not all the respondents, Lordship, it's named.
7.
No, 1, 2, 4, 7, 11, 13, 16. It's there in the office note, Lordship.
So many of the respondents remain unserved.
Yes, Lordship.
As per the office report, notices issued to the respondent number 1, 2, 4, 7, 11, 13, 16, 17, 18, 19, 21, 22, 23, 25, 27, 29, 30,
1, Lordship, 31 and 30.
and 33 remain unserved. Full stop. Lanet, concept of the appellant prays for some time to move appropriate application seeking paper publication of the notices, paper publication of notices to the unserved respondent. Time period for is granted. List on.
Any day after 2 weeks, Lordship.
Control.
I'm so obliged. Lordship.
Item 2.
Wait, please, brother.
Amended constitutional file.
Is ready for admission, Balan.
Sir?
And earlier the response number 4 names were expressed, was allowed to be considered. And that has been effected, so the matter is ready for admission. It will go into fifth now.
A little bit loud, sir, please. You are not audible, a little bit loud.
He wants the matter to be listed for admission.
That's,
I'm for
the
respondents.
as per the office rule, it's amended hospital already filed. Is this matter for admission? When? Three weeks. List on so for admission on so and so.
My lord, I am appearing for respondent number 3, my lord, in this
You are
matter.
respondent number 3, yeah.
And I have instructions to appear on behalf of 1 and 2 also, my lord. Within a week, we will file our wakalatnama.
Okay.
And my lord, 4 weeks time may be granted to file my affidavit in open.
So the service is complete on all the respondents?
My lord, it's a contempt petition, my lord. I am alleging non-compliance of the judgment dated 9/8. There was a direction to make payment to me, my lord.
Fine. Let them find their response.
My lord.
4 weeks time, my lord.
Mr. So put in appearance on behalf of all the respondents. Service is therefore complete. He placed some time to file counter to the contempt, to contempt petition. Time period for is granted. List on
My lord, 7th of March, my
7th of March. Yes.
obliging.
Item number 3.
It was already.
Item 4.
Meet with Lordship. This is a reference made by the learned single judge Lordship. The issue is whether a juvenile can file a petition under section 438 of the CRPC seeking 3 years bail Lordship. There is a concurrent learned single judge held that it is maintainable, but there is a coordinate bench judgment wherein it was held that it is not maintainable. That is why this reference before your Lordship.
This shows the earlier judgment of the coordinate bench.
Lordship,
Is dated 7th of April 2020.
Yes,
yes.
this one. I said yes. Like I said,
Lordship, may it pleases your Lordship, the matter is under consideration before the Honorable Supreme Court, your Lordship. I have come across the order, last order, wherein the Honorable Supreme Court has fixed the matter on 1/9, it was of last year, but as on date it's not updated. The same issue, the matter is under consideration.
yes, Lord.
There are conflicting judgments of various courts. I have come across the Rajasthan High Court judgment wherein references were made before the Honorable Supreme Court, my lord. And I have also come across Allahabad High Court judgment wherein it has been held that 430 application as regards juvenile is maintainable, my lord.
So we'll also hear it and decide it.
Lordship,
That's a view of Guwahati High Court also there.
my lord.
Yes, Lord.
Mhm.
Is there any order of reference by the Supreme Court?
Yes, your Lordship.
What has happened to his application?
Lordship,
What has happened to the application filed by the juvenile?
That is still pending.
that is
That
pending.
is before, your-
Anticipatory bail still pending.
still
Yes.
pending.
Some protection orders there.
No, there is no order.
The court has specifically refused the interim order or what?
Now, since it was held that since there is a coordinate bench judgment, conflicting opinions, that is why the learned single judge he was not inclined to pass an interim order.
Yeah, what's the offense?
That offense is under section 306, 386,
325, 342, 386, 325 and 307.
307. That was a,
Puncture of injury.
that was a simple injury. Subsequently, the injury report came. It was a simple injury. It was some mob violence, and juvenile was the he was a inspector. He was just looking the incident.
That's your case.
Yes, sir.
That's his case.
Yes, that is.
This reference came up before this court. Pursuant to the order passed by the London single judge on 3rd of October 2023 in case number AB/3286/2023. Whereby the London single judge has made a reference to the effect that whether an application under section 438 of the Code of Criminal Procedure 1973 is maintainable by juvenile before he is actually apprehended on accusation of having committed a non-bailable offense. ये inverted commas में करता है. Steno sir, voting जी. ये inverted commas के अंदर whether an application and bailable offense to inverted. Yes, it is informed that the Honorable Supreme Court in special leave to appeal criminal number so and so 12659/2023 is already seized of the matter. In view of the fact that the Honorable Supreme Court is already seized of the question referred before, were referred by the learned single judge, we deem it appropriate to adjourn this matter for 12 weeks. For 12 weeks.
12 weeks.
In the meantime, the applicant shall not be arrested without the leave of this court.
I am deeply
Lordship,
obliged.
today I'm not aware of, as regards the, Lordship, whatever has been submitted by my learned friend, that the injury is simple, because case study is not before me, your Lordship.
It's a matter of juvenile and the matter is pending. So without the.
I leave it to your Lordship's discretion.
State modification.
However, the state will be at liberty to move modification of order if they desire so.
I am obliged, Lord.
Complex.
Item number 5.
May I please, Judge? Well, the I for condonation of delay of 169 days in preferring the reachable. Well, on last occasion, Lordship has issued notice and directed us to take drastic steps. No? We have accordingly taken steps on the respondent number, the opposite party number 1, and we have also filed our affidavit to that effect. No?
This
Duly
is
served,
already complete.
duly served the notice. No? Yes.
So the genuine judgment imputed was passed in many of the writ petitions.
Well, it's a common general. No? On
Have you filed appeal in other cases?
yes, Malad. The one appeal we have filed in that, Malad, delay has been condoned and Lordship has stayed the judgment, Malad. And that appeal is, we have enacted the order, Malad. in the IA, my lord, lordship will find that page 13,
Page 30.
page 13, annexure 2 is the order. The fourth,
Just
kindly,
page 30.
lordship. The next page, my lord, it starts at page 13, kindly come to page 14, my lord. The instant interlocutory application has been filed seeking condonation of delay of 28 days, occasioned in preferring the connected writ appeal against the judgment dated 31/2023, passed by the learned single judge in WPC number 3245 of 2019. We have gone through the grounds set out in the application.
1 minute.
Lordship.
The matter comes upon for consideration of IA number 3680, 2023, with a prayer to condone the delay of 169 days in filing the present appeal. Stop. The notices of application under section 5 of the Limitation Act issued to the respondent has been duly served. Over none has appeared on behalf of the respondent. Full stop. Having heard the learned counsel for the parties, the learned counsel for the appellant, and after going through the contents of the application under section 5 of the Limitation Act, we are of the view that the appellants have satisfactorily explained the delay of 169 days in filing the present appeal. Hence, the application under section 5 of the Limitation Act is allowed. The delay of 169 days in filing the present appeal is condoned. Let notice of appeal be issued to the registry is directed to register the appeal. This for admission.
Lordship.
Next week, he will date.
Lordship. I'm lordship. I'm lordship.
This for admission on the next week.
Item 6,
Well, item 6 is similar, my lord. It's an appeal against the same but common judgment, my lord.
Same order,
Here, my lord, delay is 173 days, my lord.
notices.
Yes, yes, my lord. We have already
Same
taken
order
step.
कर देना, delay का change कर देना, इसमें 169 kg का 173 days कर देना, order same.
My lord, lordship. I'm obliged.
item 7,
Lordship. Lordship, in my memo of appeal, Lordship, so annexer E, Lordship, they inadvertently wrongly annexed in my appeal, Lordship. So that's why on that day I was prayed for liberty to file a fresh petition, Lordship. The court is,
Fresh petition.
yes, fresh appeal, Lordship. So I may allow to liberty to file a fresh appeal, Lordship.
Come to one for consideration, consideration of application number so and so. Seeking prayer to amend the appeal. Full stop. Having gone through the contents of the application, we deem it appropriate to allow the same. The IA number so and so is allowed. Yes. The. Allow the appellant is permitted to amend the appeal number writ appeal number 13/2024. The amended appeal is already filed. The same be taken on record. List for admission. When? List for admission after 2 weeks.
Yes, Lord.
Lordship, may I pray, Lordship? Kindly peruse annexure E, Lordship, page 113.
Yes, I stated it.
113. Yeah.
Lordship.
So inadvertently wrongly appended, Lordship, that
Lordship,
particular
that
annexure.
annexure kindly see, he has wrote a letter to the Honorable Justice, Lordship.
I'm sorry for that, Lordship. These are wrongly appended, Lordship, that particular document. Lordship.
Why only
The RAP
moved an
copy-
application for amendment?
Yes,
seeking
Lord.
amendment in the. That's why. only
Yes, Lordship. I want apology, Lordship, on that.
The letter addressed to the.
Yes,
That's why
I'm
he
sorry
has,
for that.
Judge.
earlier occasion he has withdrawn
So
that.
Lordship, matter pertaining the land acquisition, Lordship.
Okay.
So the petitioner entitled after 22 years, Lordship. The petitioner land and whole property acquired by the Water Resource Department in the year 2001. After 22 years, the principal amount has received. So my
Mr.
content.
Das, how, you are the one who has written this letter to the honorable judge.
I'm sorry for that. These are wrongly appended, my
It's a
brother.
misconduct.
I'm sorry for Lordship. It's a draft copy of the interest portion, Lordship.
Which writ appeal?
Mr. Das, writ appeal was withdrawn earlier.
No, Lordship.
Yes. Is the order?
Lordship, on that day, I was prayed for liberty to file a fresh petition, Lordship. The court did not
You prayed for
allow, Lordship.
filing a review petition only.
Lordship, the court did not allow. I was prayed on that day, Lordship. I was prayed, Lordship. But Lordship, the court did not allow. I was prayed for liberty to file a fresh petition, Lordship. So, Lordship, I'm extremely
The court was not allowed.
not allowed, Lordship.
Then how
So
did you
review-
entertain this?
Review has written, Lordship. That part I have not prayed, Lordship.
Hmm?
And that prayer, the review petition, I was not prayed. I was prayed for only the liberty to file a fresh
File a
petition.
review before the division bench. Once this appeal is already withdrawn, how can we allow you to amend the appeal?
Lordship, the prayer is very simple, Lordship. The annexure E,
Whatever the
Lordship.
prayer may be, once this appeal is already withdrawn and dismissed as withdrawn, how can we allow to amend that appeal? You should have disclosed this fact, sir.
Lordship, whatever, Lordship, the Supreme Court held one of the letters.
For all purposes, this appeal is not at all pending.
Lordship, I was prayed for liberty to file a fresh appeal, Lordship.
Even though if
So
the,
review-
division bench has passed an order which you have not prayed for that, file a review petition.
I'm sorry for that, Lordship. I will withdraw.
Sir, there is no question of any, sorry for that, sir. This is the only procedure.
Lordship, I was not prayed on that day, Lordship. This is the
Sir,
typical list, Lordship.
How can we, what transpired between the court? We are not aware of that.
Yes, Lordship, yes, Lordship.
And if you are saying that you are not prayed and the court has granted that order or passed in the order, file a review petition for that.
Yes, Lordship, yes, Lordship.
This.
I'm allowed to withdraw the I, Lordship.
This, even the matter is listed.
It's a dispose of,
How can they dispose of case now? How can they file an IA and registered it and place it before the court?
and it's not mentioned that it is in a DO, dispose of matter. Mentioned. Where, I don't see anything, where? In item 7. Huh? The DO. Okay, right. No, DO. Huh? Yeah, sure, right. Just take it.
It is noticed that the applicant has moved an application with the prayer seeking amendment in the writ appeal number 13/24 2024, which has already been disposed of by a coordinate bench wide order dated 22nd of January 2024. Full stop. Learned counsel for the applicant has submitted that he doesn't, on instruction has submitted that he wants to withdraw this application, seeking liberty to avail appropriate remedy available to the applicant. Full stop. Dismiss with liberty as prayed for. Sir, at least please
Yes, yes,
disclose all these facts and then only come.
yes, yes, sir. I'm sorry. for that.
Serious matters.
Mass of it.
Simply, we are believing on the statement of the advocates. Please don't take this liberty.
Yes, Lordship.
Sorry.
Lordship, the Supreme Court has listened judgment, Lordship, the latest judgment. This one.
Whatever it may be, you first of all, once the matter is disposed of, how can you move an application for an amendment in that matter which has already been disposed of?
Yes, Lordship. So on that day, I was prayed, Lordship, before the Honorable Court,
Whatever it
Lordship.
may be, sir, what transpired
yes.
between you and the court on that day, we are not aware of that.
Yes, Lordship. Yes,
You move and appropriate whatever the
Yes,
remedy
sir.
available
Yes.
to you.
yes, mass of it, Lordship.
Item number 8.
Yes. I'm present, let's stop in 2 weeks.
Item 11.
I'm. You are good, Mr. Krishna. Your good name is? Huh? You can, you can, you can. Yes. Is there? You'll find it in page 6 of the memo. Page 6 of it. The questions are at page. Hmm? Number 7. This one is item number 11. Is that against the item number 11. It is against the rectification of the. Is it against? I'm sorry to couldn't. नहीं नहीं सब्सटेंस आप इधर आ जाइए it's not inconvenient to you. Kindly come on this side. I think 14 assessment here. 13, 14.
Yes, Mr. Counter. Substantial question of law involved in this.
My lord, the only substantial question of law that may be, my lord, whether, my lord, explanation exerted to section 14A of the Income Tax Act, my lord, that is clarificatory in nature or not,
What is that, we have suggested any such question of?
my lord. My lord, substantial question of law A, my lord.
At page 31, your lordship kindly come to page 31, we have framed that question,
31.
31. Whether in the facts and circumstances of the case, the order dated 6 July passed by the tribunal holding that the insertion of explanation to section 14A of the Act is clarificatory and thereby retrospective in nature and erroneous. So that is the one single
Page 31.
basic issue.
It's a part of the order passed by the learned tribunal.
Yes.
Yes, yes,
My
sir.
No, what my lord, the honorable chief justice is inquiring is where have you suggested that in your memo of appeal? You have, you have to suggest it in this appeal and show us how this question arises. And the addition of appeal.
My lord, may I indicate why this question has arisen?
At least. What question of law is arising in this case, at least you suggest us, we'll consider it and then only will.
That is what we suggested, but it can be modified. May I indicate the issue, how it arose? My lord, the assessee has dividend income which is exempt under the Act, and therefore expenses relating to earning that income are to be disallowed under section 14. It's well known to your lordship, my lord. Now, we showed that so much is about 2 crore is the expenditure we have incurred. The dividend income was about 3 crore. Now, the assessing officer increased it to 10 crore. So difference addition was added. The first appellate authority upheld, but is held that the disallowance will be restricted up to the income you have. Against that decision of the tribal department went to appeal. Now, in the appeal. Okay. Oh, I'm sorry. I'm extremely sorry, my lord. I'm not very habituated to it. Kindly.
Yes.
Now, the tribunal, before the tribunal, the department argued while the amendment has been made in Finance Act 22 in section 14A, adding in subsection 1 and an explanation has been added, then even if there is no income exempt at all, expenditure has to be disallowed. The tribunal accepted that argument and then upheld the addition. Even if there is no income, absolutely no. So, but you have some. So we are against that, following that interpretation of the explanation under the Finance Act 22.
That's right, we understand that.
So this is a question of law.
There is this question of law you have suggested in your appeal, sir.
That is what may have been the wording very, very comfortable, may be not be. And may I once read again?
What I read?
Or the two. Whether in the facts and circumstances, the order of the tribunal passed by the tribunal holding that insertion of explanation to section 14A. It should be mentioned, the Finance Act should have been mentioned there.
You are reading on which page?
The question number 2.
Which page of the appeal, sir?
31.
31.
Assessment year 13-14. Assessment year 13-14. Page 31 I am reading, my lord.
31.
after the grounds. Has your lordship got it, my lord?
The appeal memo ends here. Proceeding being here.
My lord, to the question A, only those words have to be added, inserted by the Finance Act 1922. Then it's complete.
Common question.
You're referring to which appeal? You're referring to which appeal?
Advocate 1340.
Assessment year 30 only one,
No, only one.
This appeal number, item number.
Item number 11.
11.
So we have not been able to find out.
My lord.
where The item number 11.
Yes,
you have-
Lordship, my lord, there are two sets of appeals, my lord. One against my lord, order passed by the appellate tribunal in the appeal filed by the my lord department, and other one, my lord, they have against that order, they have filed in my lord rectification petition,
Which is that appeal?
my lord. My lord, now, my lord, item number 11, 21, 22, 23, those arises out of the my lord order passed in rectification petition.
The council is referring to
don't have to leave.
the question,
My lord, that is my lord,
item number.
My lord, my miscellaneous application is down below. I am the main order,
no,
from the main order. I am not at the moment
Numbering
of
is
the
not
miscellaneous
mentioned
at
in
all.
the record.
No, but the major also. ये बोलते थे
My lord, I am not on the miscellaneous application. I am item number 11. That is the main order. Original order of the tribunal. May I hand over the,
Mr. Chetia.
may I hand over my brief?
Just a moment. Mr. Chetia,
my lord,
we are a little confused. Can you please assist us?
Lord.
There are 4 appeals, item numbers 11, 12, 13 and 14.
Yes.
And then again, there are a
Hmm.
few appeals from item
Assessment year,
21, 22, 23.
involved.
These are also by the same party,
my lord,
correct?
my lord,
Now, there are 7 appeals in total.
my lord.
Is that
Eight-
correct?
8 appeals,
Okay, even item 20 is there.
my lord.
So what are these 8 appeals about? They are against the same order.
My lord, they are against two orders, my lord. Item number, my lord, so far as item number 12, 13, 14 and 20, as per my lord, my record with the
12, 13, 14 and
20,
12, 13, 14 and 20. Yeah.
20.
11, 12, 13, 14.
Those arises, my lord, against the order dated lordship 6/7/2022 passed in the appeal by the ITAT, my lord.
that's a final order.
That's the final order.
All right.
And my lord, in item number lordship 11, 21, 22 and 23 lordship. Those appeal, my lord, filed against my lord, order dated lordship 2nd of January 2023, passed in my lord,
Miscellaneous application.
miscellaneous application, my lord, under section 254 of the act.
Miscellaneous application was filed for what? What?
Seeking rectification of the order, saying that, my lord, there was error apparent on record, face of the record, so they have filed a rectification petition which was disallowed.
So practically, these were review petitions.
My lord,
A sort of review
Sort of
application,
review.
my
All
lord.
right, all right,
I appreciate.
all right. So, since the prayer for review has been rejected,
my lord,
so the original orders are intact.
lordship,
6/7/2022 order remains.
lordship,
Yes, so
Lord.
therefore, these 11, 21, 22 and 23,
lord,
does not survive, we'll
My
close
lord,
it and the
my lord.
issue will be looked
Yes,
into
yes,
in the
lordship.
other 4 appeals.
In fact,
There is
my
no
lord,
need to file other
Yes.
appeals.
in fact,
Order
appeal is not
47
maintainable.
Rule
lord.
7 makes it very clear that if a prayer for review is rejected, it is the original order which has to be challenged. So these 11, 21, 22 and 23 will close it.
Yes, yes,
And
lordship,
we'll
that is
admit
not
the other
maintainable,
4.
my lord, under the, my lord,
We'll
268.
admit the other 4 on substantial, on the.
My lord,
questions of-
if I may respectfully submit, my lord, the miscellaneous application is certainly for seeking
Clarification.
Seek-
Clarification.
seeking rectification of that or withdrawal of that order and then. Now, but we are pressing for the time being, my lord, this main appeal,
Yeah, that-
main appeal itself. I can skip over or I may not. So main appeal is the substantial question, which is a question which will be alive always. It's a pure question of interpretation, even if the only one question is required. Yes, the explanation. Huh? Yeah. My lord, why I respectfully submit is,
Yeah, we understand. You please, listen that order. Will, what we are passing, please. Okay. Item number. This,
11, 21, 22 and 23.
12, 13, 14 and,
12, 13.
12, 13, 14.
they may be heard together.
Just a minute, 12, 13, 14 and
20 law,
20.
my lord.
Yes. Having heard the learned concept of the parties, we are of the view that following substantial question of law are involved in these appeals. This item, page number 30 and 31, where there are 2 questions, 30 and 31 page. Issue notice, Mr. Chetia,
Lord,
put in appearance on behalf of the respondent, services therefore complete.
lord.
अरे बाबा इतना सारा question. Oh, only 2, yeah.
But admit notice is already issued, Mr. Chetia put in appearance on behalf of all the respondents. Let these appeals be listed for final hearing in due course.
In the
Due
month of
course.
May, first week.
As soon as your lordship pleases, my lord, we are ready to, all the papers are here. If your lordship want, we can make a paper book fresh or all on the same papers, it can be done.
First week of May,
Clear plan.
in view of the order passed by this court in
I'm deeply obliged.
ITA number 4/24.
All the,
6
all the 8.
7/24 and
हाँ?
2/24.
अरे आप बोलिए हम
We are of the view These appeals seeking clarification of the impugned these appeals preferred against the order dated 2/1/2023 passed by the ITAT seeking clarification, rectification of the original order dated 6/7/2022.
Are you done with?
are redundant and therefore the same are treated as disposed of. Redundant in view of the fact that appeal against the original order has already been, appeals against the original order has already been admitted. Be treated as disposed of all of the purposes.
Milord,
Deeply
one prayer, if I may respectfully make, Milord. The stay, because pursuant to that, there has been, the order may be stayed.
The order is dated 6/7/2022
My lord.
and
In fact,
this order is also a year old.
my lord, appeal was preferred in the year 2022 itself, my lord.
22 itself, please.
Deeply obliged.
There is no application for stay also.
That's another,
Your lordship kindly,
that's another aspect.
Milord, there
There
is
is no even
substantial,
application for a stay.
may I respectfully, your lordship kindly allow.
Move appropriate application, we'll see.
Move appropriate.
Yes,
Yeah.
next.
Move appropriate application. Appropriate application for stay.
Item 15.
You have withdrawn the earlier appeal? Why you have withdrawn the earlier appeal?
Lord, because due to some clerical mistake, that is why the learned friend raised some questions regarding pleadings, your lordship. That is why the honorable court given the liberty me to file a fresh writ appeal, your lordship.
Two times. There is an allegation against the court lordship in the pleadings.
And
So
this is
again,
not
here
question-
also I have found from the record, there is a delay of 75 days. In the website lordship, but how it came,
No,
no delay condemnation petition is also there.
How delay, your lordship? The honorable court itself granted us to given the liberty to file a fresh writ appeal, your lordship.
So 25 days.
This is pointed out already a delay of 75 days.
No, my lord, as the honorable court given us the liberty, your lordship will find annexer.
That may be appropriate ground
My
for
lord.
condoning the delay, but at least you have to move an application for condonation of delay. That may be a good ground for condoning the delay. That seems earlier you have
No.
filed an appeal and then after the court has granted you the liberty, then we can consider it for a good ground for condoning the delay. But and once
But earlier writ appeal, your on, earlier writ appeal, your lordship will find
But you have to move an formal application for condoning the delay. We'll consider it and we'll condone the delay, but at least you should move an application. Once the office has raised the objection that appeal is 75 days delay, how can we entertain this appeal without condoning the delay, sir?
You will see, earlier readable, I have filed a readable within a period, your lordship.
We are also.
Subsequently, then
Mr. Counsel, you have to move an application for condonation of delay. That's why we are of the view. And if you don't want to file, we'll consider it, then we'll.
then your lordship.
Grant. It is notice that the office has pointed out that there is a delay of 75 days in filing the present appeal. However, no application under section 5 of the Limitation Act seeking condonation of delay is filed. Then a counsel for the appellant prays for and granted 2 weeks time to move appropriate application for seeking seeking condonation of delay list after 2 weeks.
Highly obliged. Item 19.
Lordship. I sincerely apologize, Lordship. I could not get preparation yesterday because of certain medical issues.
Item 24.
Here is the matter pertains to removal from service, my lord. And learned single just observe order it page 195, lordship, and operative person page 207 para 14.
Yes.
And then, my lord, in paragraph 13, it is stated, my lord, from inquiry report that the medical documents were also taken into court. Whereas, my lord, the lordship will get that medical I exhibited at page 77 annexed in the inquiry report itself. It reflects, my lord, page 77. I'll have to draw your lordship.
You are.
Yeah, I exhibited.
Seeking the psychiatric treatment.
Yes, absolutely. It's so let me on records, matter. I prayed for lesser punishment instead of removing me from service, my lord. That was my only prayer, my lord. Though I have enclosed all my medical documents, my lord. They've stated that only no reason as whether consideration or non-consideration, my lord. But though Lanet Singh recorded that they have taken the consideration.
Yes, Mr.
My lord, here in this case, my lord, ample opportunities were given to him at the time of hearing, my lord. So the petitioner could not, the appellant could
But the
not.
fact remains that he was seeking some treatment from the psychiatrist.
Yes, OPD, my lord. But that doesn't mean that he was not in a position to join the duty, my lord. Because the report says he had the.
Once if he was going treatment, undergoing treatment for some psychiatric problem, then obviously how can he join the services without there being any sound state of mind?
My lord,
Notice.
my lord,
Let us see, we'll hear.
My lord.
You should notice this one so is appearing on behalf of the respondents. All the respondents.
All the respondents.
All the respondent services therefore complete this appeal for admission, for hearing in the month of June 2024.
Item 25.
Who's for the petitioner?
For the petitioner, Mr. Giri, they took on earlier occasion also. They
Not
took
present for the petitioner list up 2 weeks.
lot.
Item 26.
Make please, your lordship. Honorable single judge order is page 217, lordship.
What's wrong in that?
Lordship. Ground is that, lordship.
You sought permission to undertake CEO to open 5 years full-time bachelor architecture course for session 2020-21 only, and that period is already over now. What-
Lordship, for that I am before your lordship. Lordship, my application can be considered for the next session, lordship.
That.
And
the
apart
Leonard
from
Singh
that-
Is already granted you liberty.
Lordship, without any order from this owner, because I challenged the lordship, I deposited 5 lakhs rupees, lordship, and they are demanding the rupees 20 lakhs for another 20 lakhs by virtue of the order of that.
Another 20 lakhs, they are demanding pursuant to the resolution,
Lordship,
that is, this 24th of August 2020,
Lordship,
resolution number 490.
lordship,
Challenge that resolution if you are agreed by that. The Leonard Singh is rightly held. That
lordship.
means you have not challenged this.
I am, lordship, with all respect, lordship, because their minutes is already pending before the government. They have no approval as learners and central government already admitted in their affidavit, because there is no such approval in their lordship. I have in their affidavit, lordship, of the central government, lordship, page 207, lordship. There is no such specific approval in their lordship. And
We don't find any illegality in them.
lordship, my resource submission regarding the approval, since there is no such approval from the central government, lordship, which is already admitted in affidavit page 207 of the central government, lordship.
Of what?
approval of the central government, Lordship.
This COA, what is the COA?
It's the Council of Architecture. my lord.
Council of
Statutory
Architecture.
body
Architecture
under the Architecture Act.
As per Architect Act, Lordship, 72, which required approval of the central government.
Then you mean to say that this resolution of the COA or in 69 minutes cannot be taken into consideration.
Lordship.
Then challenge it.
And apart from that, they have issued, by virtue of that letter, Lordship, they have issued annexure. Page 50 is the interim order, Lordship. I am agreed by that, Lordship.
24th of August 2020.
Lordship. Page 50, Lordship.
So without there being any challenge to that resolution, how can you maintain this petition, sir?
I am agreed by that only, Lordship. And
That is inconsequent to the resolution passed by the COA.
Lordship, Lordship.
So first you
Once,
challenge this
Lordship, that
resolution.
honorable court can mold the relief on that point, Lordship. My respect to submission, Lordship. As the central government, they have admitted, page 207, there is no such approval from the central government.
It's another-
And apart from that, Lordship, the honorable single judge may consider for next session for my application, which I am relying some one judgment of the honorable apex court, Lordship, 2015 SCC 845, Lordship. I am supplying the two copies, Lordship. Since the application is for 2020 and 21, for next session, my application can be considered for that. If that part is
Yeah.
there,
Your application may be, we may grant you liberty or give a direction to them to consider your application for next session also.
Lordship, that part,
But till the existence of this resolution number 498, again the same question will come.
Exactly.
They'll again ask you 25 lakh rupees and again you will say,
Lordship,
I'm
if-
not going to pay that.
let them first, Lordship, if they raise, because that part, that session, Lordship, may I read, Lordship,
Again, what is this game?
paragraph 23 of the said judgment, Lordship. Honorable apex court held that the considering the stated time schedule and the same is already, may I read, Lordship?
Yes.
And the facts and circumstances of the case, it would be appropriate to direct the instruction to made and thereafter decision to be taken for the current academic 2015, as that would be in breach of law laid down in the various decision of this court, which is binding. Thus, we direct that the application has been submitted by the college for the academic session 2015-16 be considered for the next academic session, Lordship. My respect to submission, only that part can be considered. If they will raise,
Anything else?
Lordship, since that part, Lordship, may be kept open, Lordship,
Yes, we'll
Lordship.
consider anything else.
no, Lordship, this apply.
This writ appeal is filed by the petitioner being agreed with the order dated 9/3/2020 passed by the learned single judge and writ petition, WPC 508/2021, whereby the writ petition filed by the petitioner has been dismissed as having been infructuous while granting liberty to it to approach the appropriate forum for the appropriate forum for redressal of its grievances, regarding the resolution number 498 taken by COA in its 69th meeting held on 13th and 14th of April 2018. Full stop. In the writ petition, the petitioner has challenged the letter dated, challenged the validity of the letter dated 24/8/2020. Appellant has challenged 24/8/2020 passed by the sent by the COA, whereby the appellant was directed to deposit a amount of rupees 25 lakhs for the purpose of conducting 5-year full-time Bachelor of Architecture course. Full stop.
For the sessions.
For the session 2020-21. Full stop. The learned single judge has observed that the letter dated 24/8/2020 was sent by the COA pursuant to the decision taken in the COA, taken by the COA wide resolution number 498 in its 69 meeting held on 30th and 14th of April 2018. However, the appellant has not challenged the validity of the said resolution, and therefore therefore the relief paid for in the writ petition cannot be granted. The learned single judge has also observed that the appellant has prayed, the appellant has sought approval for opening 5-year full-time Bachelor of Architecture course for the session 2021. And since the said period is already over, the writ petition being infectious is liable to be, infectious is liable to be dismissed. Full stop. Learned counsel for the appellant has submitted that though the application filed by the petitioner seeking approval from the CO to open 5-year full-time Bachelor of Architecture course was for the session 2020-21, but this court can direct the respondents to consider the said application for the further academic sessions. In support of the same, the net counsel for the appellant has placed reliance on the decision of the Honorable Supreme Court in Padma Shri so and so reported in so and so. Having heard the learned counsel for the parties and after going through the material available on record, we are of the view that the learned single judge has rightly held that without there being any challenge to the resolution of the CO, on the basis of this, on the basis of the letter dated 24/8/2020 was sent to the appellant, no relief can be granted to it. Full stop. The learned single judge has also rightly observed that since the petitioner, the appellant was seeking approval from the CO to open 5 years full-time Bachelor of Architecture course for the session 2020-21, and the said period is already over, the writ petition being above the writ petition has become infectious. Full stop. The reliance placed by the learned counsel for the appellant on the decision of the Supreme Court rendered in Padma Shri Dr. So and so Supra is of no help to him, help to it, as the facts of the said case are clearly distinguishable from the facts of the present case. Hence, we don't find any merit in this appeal. The same is therefore dismissed.
Item 27.
That be allowed.
May I, I'm appearing on behalf of response number
Hello.
5.
Here.
Point out, my lord, at the outset, the matter was heard by earlier bench, and my lord, petition was up to be dismissed and judgment was reserved.
No, no.
But that is
It's,
it. Then matter unfortunately, no judgment could have been delivered. So matter was relisted. Then matter was heard by another coordinate division bench. Bench of coordinate jurisdiction. And court was also of the view that petition maintained, appeal is not maintained. Then some time was sought for by the appellant, to get some instruction from the client. So today, my lord, just for applying the court, my lord, but this instruction he received. Whether he is going to withdraw the matter, appeal, or court is going to be dismissing it.
Let him take his chance here also. He may also endorse the same view of the earlier benches. Yes, Mr. Is it true?
No, my lord.
Is it
It's,
true?
it's not that, my lord. Because rather,
You
the,
got time to complete instructions?
yes, no, my lord, since the petitioner was supposed to whether he will continue or withdraw his petitions, my lord, since the session has already been.
That can only be in one eventuality when the
No.
court is going to dismiss the.
Yes, sir. No. That part, my lord, only session already been expired, my lord. That
Session already
the session already been my lord,
commenced.
already been convinced, my lord, that comments and already
Substantial
on
part of
30th
the-
30th of September, the classes were started, my lord. And accordingly, my lord, the period has been accordingly, my lord, already extended, my lord, the classes and these other things have gone out, my lord. So I told him that what to do. Then he said that to press the matter, my lord. To press the matter so that in the next academic session also, this Honorable Supreme Court also said that when the candidate was selected for MBBS my lord, quota, my lord, under the OBC NCL quota, my lord, then abruptly, without giving him any notice, his selection has been cancelled, and the candidate who were the general category from initial to last stage, he was the general category, my lord. He did not apply. She did not apply for OBC NCL category, my lord. And I was all along OBC NCL candidate, my lord. And she did not apply only on the basis of the High Court's order. Abruptly on 29th of September.
So there was a high court order in.
High Court order, that order was not to the effect that you cancel my selection and from.
Without there being.
Yes,
Without there being creating any vacancy, even by cancellation or whatever it may be, how they could have implemented the High Court order.
The High Court order is also in different way, only to issue the OBC NCL certificate, not to oust me. That order is not there to oust me. Lordship will find the order of the single judge, my lord. Lordship, kindly have a look, my lord.
That judgment was not.
That page 95, my lord. Page 95, my lord. And the single bench order did not say to oust me, my lord. Lordship, have a look at since para 6, my lord. Para 6, 7, my lord. Only she was for not issuing the OBC NCL, my lord. In view of, may I read, my lord? 98, relevant para, this page 98, my lord. In view of the rejection of the application of the daughter of the petitioner for non-criminal layer certificate by the order dated so is set aside and the matter is remanded back to the Deputy Commissioner Sonitpur to issue an appropriate non-criminal layer certificate to the candidate, namely Sayana Kasab, by taking note that only one of the parents is a working parent and she is working in the category 3 post. And therefore, under the law is entitled to non-criminal layer certificate. The certificate is be issued in course of the day, issued in Massachusetts. It is a matter of admission to a medical college. The daughter of the petition is also directed to immediately approach the director of medical for doing the necessary formalities. The director of medical education to take note that there is already a declaration by the court as regards the entitlement of the daughter of the petitioner for non-criminal layer certificate, and therefore, even if there is a delay on the part of the Deputy Commissioner Sonitpur to issue the certificate, and same shall not reason not to give the admission to the daughter of the petitioner, provided she is entitled to the merit in all other aspects. And she was general category. How she can come in the last part of the after then lordship,
maybe for whatever reason.
then lordship will find the
come to
impugn order.
Conclusion that she belongs to the OBC NCL category and therefore issue a certificate of this effect to her.
My lord,
Further direction to consider that whether she is more meritorious than you or not.
Yes, yes, regarding meritorious, my lord, that is different thing,
She is
but
more
yes,
more
yes,
meritorious.
yes. But lordship will find as per the, just me, as per the NEET guidance is there, my lord. As per the NEET guidelines, my lord, the person who applied for OBC NCL, he or she has to apply immediately at the time of registration, my lord. That as per the public notice.
Her grievance was that though she applied for non-creamy layer certificate, they issued a creamy layer certificate on the ground that your mother is serving in the government. The net single judge has considered that and said only on because of that, then she can't be treated as a creamy layer and issue a certificate of non-creamy layer and consider her candidature.
My
This is
lord,
what the case is.
my lord, since there is a, my lord, the thing is this, my lord, as per the notice, had there been, she applied for under the OBC NCL and the NCL certificate was not issued, then matter is different. 2 times notice was given, my lord. Even the director of medical education on 1st of July, they have issued a certificate that if issued a notice saying that if anybody is left out.
Mr. In the writ petition, you were not a party.
Yes, I'm not a party.
So the relief was not against you.
Not against me.
The writ petitioner was aggrieved due to the fact that despite her application, NCL OBC certificate was not given to her.
Yes.
The learned single judge came to a conclusion that since it was a case of a single parent working in a grade 3 post, she was entitled to that certificate. You have not assailed that finding.
No.
You are aggrieved because as a consequence, as a sequel to the order and the certificate issued to the writ petitioner, you were ousted from the realm. That is your grievance.
Yes.
But if the judgment, if the order of the learned single judge is not assailed, then the consequences will happen. What can be done about it in a writ petition?
No,
We can feel today.
Since, my lord, I have come before this honorable court, my lord. No, since I have come before this honorable court, my lord, that part already I have brought into this writ appeal, my lord, saying that because of this things, my lord, this is happening. And now, my lord, at least once I have been selected, my lord, I have been selected on 28th of
Where's the impugned order?
lordship will find the
Order passed by the learned single judge which is impugned in this petition.
And order is beyond.
on that observation was made and accordingly a notice was issued. No such interim order was passed. Accordingly, I have come before lords.
You are assailing the order dated 29/9/2023.
Lord.
No, my lord.
No.
That
Selling the order at page 99. There's a
99.
separate, he preferred a separate writ petition, my lord, claiming admission. He has not challenged the order by which the respondent 5 has got the admission. That has not been put to challenge in the present appeal.
that part, my lord, only I have when I have filed the writ petition, then and only I have come to know all this fact. Man.
Sir, the impugned order which is under challenge in this appeal is which order?
Page
Tw-
98.
29, my lord.
98.
Lordship will
Page
find
number 98.
page
That order 29/9.
The
20
same order,
page 100, my lord.
100.
Yes.
No, it's a part of page 98.
This is the notice 29/9/2023.
Yes.
Sir, this is the writ appeal or writ petition? This is a writ appeal.
Writ appeal, my lord.
So which order you are challenging, sir?
Yes.
Sir,
My lord, page 98 is the, my lord, the writ petition where the order was passed, that is 5/10/2023, page 99.
5/10.
5/10/2023.
Page 8 starts from 89, my lord. Page 89 of single bench order.
No, that's a wrong.
Huh?
Lord, you will see the page 16, my lord,
There's
the
some
prayer.
problem with your pagination. It's in page 19.
89. Single bench order 89, my lord. Page 89. नहीं तो 89. It is 89.
It is still pending.
It's still pending, my lord.
That is still pending, my lord.
That since it has no
That was earlier heard, judgment was reserved but couldn't be delivered.
No, could not be, because already Honorable Chief Justice was elevated, my lord. That is why.
It seems it's a lucky case. I will also reserve the judgment.
No, my lord. Since in the case, my lord, already we submitted our written argument also, my lord, by relying the Supreme Court judgment, and the Honorable Chief Justice was also pleased to hear the matter regarding.
Your writ petition is pending.
Yes.
Dispose it off with liberty to you to approach the learned single judge for early disposal of the writ.
No, since
It will again create many things. Once the writ is pending and we are, if we pass any interlocutory order in this appeal, that may create another confusion.
no, otherwise that in the single bench, my lord, here this observation has been made that the single bench in earlier occasion, the single bench has passed the order. On the basis of that, this impugn order has been passed by the Director of Medical Education, and that is why I have been told that this single bench cannot go by this or to pass any order, since you have to go to the higher court. That observation was made, my lord, that because of the this lordship will find, as per this page 90, my lord. I'm just reading, my lord, that
yes,
that question has been raised, my lord, that had so and so Lardon cause for the petitioner who has filed this petition with regard to admission in so and so. It is the case of the petitioner that he had applied in the national eligibility come entrance test so and so, and had secured 430 marks so and so out of so and so mark in the category of OBC non-criminal layer. The petitioner was also selected for admission by select list so and so, and was asked to report to the Kokrajhar Medical College. However, it is submitted that pursuant to an order dated 29/9/23 passed by this court in WPC 573023, the admission notice of the petitioner has been cancelled, and in its place, the respondent number 5 has been allowed to be admitted. It is stated that the respondent 5 had applied as a general category candidate and had changed her category during the process of admission, which is not permissible. Mr. So and so, health and so, as per the submit at the outset that as per the law laid down by the Honorable Supreme Court in the case of Midul Dhar and so 2005 to SCC 64, the last date for admission in MBBS has been fixed on 39/9/23, which is not to be extended. He also submits that the impugn action has been taken in compliance of the order dated 29/9/23 of this court passed in WPC number 573023. He has further submitted that the projection made that the respondent number 5, who has been accommodated in place of the petitioner, that she belongs to general category, is primarily incorrect and so and so. And accordingly, my lord, on the basis of this court's order, this 29/9/23, my lord, I've been told that
1 minute. This order is attained finally. Mr. Gogoi, this order dated 29/9/2023. It has attained finality.
Yes, sir.
There is no appeal against this order.
No, he has not preferred any appeal.
He was not supposed to. How he come to know that by passing of this order, his admission is going to be cancelled.
My lord. In fact, my lord, at least on the day when the writ petition was moved on 5/10, it was within his knowledge. Thereafter, he preferred this writ appeal. He ought to have challenged it, my lord, by seeking a leave, my lord. He challenged the order whereby his
Mr.
interim plea
Chetri.
was rejected. He had the
Mr.
time.
Chetri,
Lordship.
you probably would have challenged the order dated 29/9/2020.
Yes,
Instead of doing that, you challenged the order where nothing was decided.
Lord.
Merely because it was observed that by 29/9/2023, this issue has been dealt with.
My lord, that part, my lord, since I have also gone through the.
Definitely, Mr. Counsel, when your writ petition is pending, we don't find any case of interference in
No.
the order whereby the court has declined to pass any interim order.
No, since my lord, it was supposed to be pass the order as a whole, my lord, after hearing all this, the hearing part was concluded in 19th of September, my lord,
By whom?
by earlier this bench, my lord.
Okay.
19th of October, my lord. Then it was supposed to be passed, my lord. Since it was hard at length, my lord,
Would have been passed, maybe what order they.
and
We are not aware.
judgment was reserved, my lord. Since this honorable court,
We'll dispose it off. Don't you worry, we'll not reserve the judgment, we'll dispose it off.
my lord,
Here now.
yes, and my lord, since my lord lordship is aware about this S. Krishna Shraddha case, my lord. The last part, my lord, I'm just reading for lordship's the para 9(3), my lord.
Yes.
Just I'm reading for lordship's, my lord. In the case, the court is the opinion that no relief of admission can be granted to such a candidate in every academic year, and where it finds that the action of the authorities has been arbitrary and in breach of the rules and regulation or the prospectus affecting the rights of the students, and that a candidate is found to be meritorious and such a candidate, public student, has approached the court at the earliest and without any delay. The court can mold the relief and direct the admission to be granted to such a candidate in the next academic year by issuing appropriate directions, by directing to increase the number of the seats as may be considered appropriate in the case, and in case of such eventually, and if it is found that the management was at fault and wrongly denied the admission to the meritorious candidate, in that case, the court may direct to reduce the number of seats in the management quota of the year, meaning thereby the students who were denied admission illegally to be accommodated in the next academic year out of the seats allotted in the management quota. this, in the larger bench of the Supreme
No
Court.
quarrel about this proposition,
Yes.
but you can very well argue before the learned single judge for that purpose.
My lord,
No quarrel about that.
no, since my lord, I have approached and I have been told,
You have approached only being agreed with the action. The learned single judge has not passed any interrogatory order. Still, the matter is sub judice. On merits, the learned single judge has to adjudicate what you are saying, whether you can be allowed for the next session or not. Not in this intra-court appeal, merely again, which is
Since,
filed merely
let,
against the order whereby interim relief is declined.
but only, yes, my lord, only unless your lordships will interfere the matter. My lord, since in the single bench, my lord.
Will happen to that writ petition? If we interfere here and decide all the things here, writ petition, what will remain to
Well,
decide?
in the writ petition, I have been told that unless and until that that will be interfered by the higher court, nothing will happen.
So that's
So,
one of the possible view, and prima facie, we are also of the view that that's right view.
so unless this honorable court,
It's better to get an order from the learned single judge and then come before us, we'll again consider.
then already been, my lord, this academic here already gone by, my lord.
Yeah, have an order, final order, and then come.
Nothing will happen because now again from March onwards, again another session will start, my lord.
We'll
So,
we give you the liberty to approach
because-
the learned single judge for early disposal of the writ petition. You make a request, we'll consider.
Nothing will come out, my lord, if otherwise lordship is not
Here also.
interfering.
nothing will Come out, sir. Here also nothing will. come out. What do you want? What do you want, sir?
As your lordship, please, now I can.
Lordship, you want order on merit, or you want to withdraw this with liberty to approach the learned single judge to get the early disposal of the writ petition?
No, none, in the single bench, my lord, nothing will come out, my lord. The lordship may pass any order, my lord, if
So,
anything is.
indicate this. writ
Because,
petition is- this intra-court appeal is filed by the appellant, being agreed with the order dated 5/10/2023 by the learned single judge in writ petition WPC 5934/2023, whereby while issuing notices to the respondents, whereby the notices have been issued to the respondents and time was granted to them. Notices were issued to the respondent. Learned counsel for the appellant has submitted that while issuing notices in the above referred writ petition, the learned single judge has not considered the prayer of the appellant to grant interim relief during the pendency of the writ petition. Stop. We, having heard the learned counsel for the appellant, and after taking into consideration the fact that the controversy is regarding the cancellation of the admission of the appellant in NEET, which course is this? MBBS? course?
MBBS.
In MBBS course.
2023.
We are also of the view that the learned single judge has not, has rightly not passed any interim order in the matter. Interim order while issuing notices in the writ petition filed by the appellant. Hence, no interference is called for. However, the appellant is at liberty to make a request before the learned single judge for early disposal of the writ petition. With these observations, appeal is dismissed. This writ appeal is dismissed.
Is it a case of cancellation of admission or denial
Yes.
of admission?
Cancellation of admission.
Cancel.
For compliance of the.
And that too without following the natural justice, my lord.
IA, pending IA is also disposed of.
Published.
Now.
Supplementary list for orders, item 32.
Yeah, please, Lordship. Here, I, Lordship, pertaining to condonation of delay, 19 days delay, Lordship. Mention.
Very good. Issue notice of the application or subscribe the returnable long-term.
Highly appreciated.
Item 33.
May. This is an appeal, my lord, against the refusal of granting interim order. As applied by this order, impugn order, my lord, the entire writ petition is appears to be disposed of. Whatever was decided, it has been decided in the writ petition. Your lordship may kindly speak to appeal the judgment of bail. Yeah.
Madam, page 344, it starts, Madam. 344, Madam.
Judgment to is given. Judgment to.
Page 74.
LCP.
Example, Madam, 8379.
Yes.
My lord, your lordship may kindly come the concluding portion of the judgment, page 381. In view of the conclusions reached by this court, herein above, and in the light of the decision
Council, the Ranjit Singhal judge has made an observation that these are tentative observations.
already said that.
These are the
This-
tentative oppositions and not binding at the time of final adjudication.
May not be
of the
binding,
issue.
my lord. This is a prejudicial order against my entire writ petition is appears to be disposed of. Becomes infraction. This 12th Monday is the last date for.
Monday is the last date for
My lord, for submitting the online application for participating in the recruitment
Exam.
process.
in which examination?
The recruitment process, my lord, which is ensuing, we are participating candidates now.
No, my lord, my keeping it to be decided, my lord, my now prayer is the same prayer before the learned judge also. That we may be allowed to fill up the form, to appear in the exam. And date is 28th February for returnable date. So we'll be greatly prejudiced. And balance of convenience is
Yes, Mr.
Lordship, the law is very well settled. Number one, the notification of the central government NCT of 23rd August 2010 very clearly stipulates the minimum qualification, which requires 2 years DLED course. What they are doing is 18 months DLED course, and that 18 months DLED course was allowed in a special circumstances in 2017-18, when the in-service candidates, in-service teachers who does not have the qualification, if they do not complete it by a particular timeline, that was 31st of March 2019, then their continuation in service would be over. They won't be qualified to be a teacher under the NCT guideline. Therefore, the central government, under a special situation, started the process of having an 18 months DLED course for the in-service candidates.
Only for the in-service.
Only for the
not
in-service,
fresh recruits.
not for the safe fresh recruitment. Now we are going for a fresh recruitment, and thereafter in 2020 and 2021, in our recruitment process, we allowed the 18 months DLED as qualification, eligible qualification, on the basis of two judgments, one from the Patna High Court and another from the Tripura High Court. So we are in favor of them till the Supreme Court's recent judgment came up. Now the Honorable Supreme Court says that 18 months DLED and 2 years DLED are totally different qualification, and NCT has not issued any notification giving equivalency of the 18 months DLED with the 2 years DLED course.
This Javir's case.
Yes, Lordship. Paragraph 43 onwards. And the NCT notification of 23rd August 2010 has not been tinkered with till now. No modification. So we cannot play with the eligibility criteria, Lordship. Page 167 is the 23rd August 2010 notification. Minimum qualification from class 1 to class 4, senior secondary or its equivalent with at least 50 marks and 2 years diploma in elementary education by whatever name known. So the Honorable Supreme Court in the Javir's case also taken into consideration this aspect.
Counsel. The Honorable Supreme Court in Javir's case has clearly held this 18 months diploma is not equivalent to 2 years diploma.
Yeah.
Held. Then what remains in this?
No, my lord, your lordship will see that they are saying that it is for the in-service people,
Yes.
this 18 months. We are all in-service people.
Even though if we admit it is not for in-service people and for old and for also fresh candidates also, but so far as equivalence is concerned, when the this minimum qualification is 2 years diploma, how can we equate the 2-year diploma with 18-year diploma in the absence of any equivalence issued by the competent authority?
No, my lord, this provision was made, those who were not properly trained up. And these 2 years is not there. So in order to give effect to that, these persons, now they want to apply it because of that 18 months business we have
Sir,
done.
how do you distinguish the Xavier's case? Supreme Court judgment, how you are distinguishing this case?
1921 or 23, they have absorbed similar security. No, the government is acting on that. 1921, 23.
But
they have,
after this judgment came in, the Xavier's judgment is delivered on which date?
November 23. November 23, my lord.
How can then, how?
No, your lordship will see some of the communications, January later on. Yeah, the ballot plus item. Raise to now. January later. Page 284. Your lord, এখন লিস্টে বানাই তো জানি 284 correct. Model is again. Your lordship may kindly.
Mr. Advocate General,
Lordship.
allow them to, you consider their candidature provisionally and may not declare the result without the permission of the court.
Absolutely, Lordship. I have no difficulty on that.
Yeah.
The issue is that there are a huge number of candidates.
Yeah.
It will upset the whole recruitment process. We have to
We'll
keep.
simply say, consider their application provisionally, don't declare their result. That would be subject to outcome of this appeal.
I have no difficulty on that. Lordship.
Only the applicant.
Only the appellant, not the other persons, not. general
101 here.
Huh?
100 and here.
Total 164.
One, 164. In respect of them, we'll we'll accept the applications, we'll process also, but will not declare their results.
Yes.
And in the meantime.
And in my only humble submission would be, Lordship,
Yes,
as we have already appeared, and this is a pure question of law,
Fine.
we will not file any affidavit also.
Then
Lordship may be pleased to fix up the matter for final disposal at the earliest, convenient to the honorable court.
The notice is issued till 28 February. Rate petition.
petition.
other matters are also there, you?
No, only 2 matters, my lord.
2 matters.
Only two.
We have 2 matters,
2 matters are the same matter.
33 and 34. 33, 34. लिखना है. Mr. Advocate General put in appearance. on
Only one, Lordship, observations I am praying for, that today is Friday and the last day is Monday. So once after Monday, Lordship, lot of new petitions will come up. So that Lordship may be pleased to.
This is not
That-
treated as.
They have come within time. They have come within this group.
That is the idea of the single judge. Why should we bother about it?
Because they will, so this order,
Okay, nahin. We'll
that
take care of that.
these people have come before 12. 12 is the last date. The others will come on 13, 14. After that,
No,
time-
they will be qualified.
Is there any other writ petition now pending?
no. Not to our notice, Lordship, till now.
They have approached the court betting time.
The floodgate will open. That is my only concern, Lordship.
No, we'll take care.
Lordship.
Mr. Advocate General put in appearance on behalf of all the respondents, having heard the learned, having, respondent number 3. Okay, Mr. Advocate General put in appearance on behalf of the respondent number so and so, and the Mr. So and so put in appearance on behalf of respondent number 3. Having heard the learned counsel for the parties for quite some time. We deem it appropriate to direct the state to allow the appellants direct the, applied already, they have already applied.
They have not applied, I think.
They have not applied.
They have not applied. The system will
Allow
not
the
take it.
appellants to apply in the recruitment process. And if any such application is filed.
Advertisement dated 26/12/2023.
Yes, madam.
26/12.
The recruitment process initiated by advertisement dated 26/12/2023.
Online apply.
23, if the application, if any such application is filed by the appellants, full stop,
Advertisement.
appellants by the next, by the last date of
एकदम अपना
That is
submission of
12.
application. By
5
the
PM.
last date of
These are all
submission of
online
application,
applications.
full stop. The candidature of the petition appellants be considered provisionally. However, the final result of the final result of them shall not be declared without the leave of this court. Full stop. It is made clear that this interim order is in respect of only appellants, and on the basis of this interim order, no right is created in favor of those persons who have not applied, who have not approached the court before considered
12
12
February, 5 PM.
application का जो date था,
Lord,
Date of submission.
last date of submission is 12.
before the last date of submission of application in respect of the advertisement dated 26/12/2023.
One more thing, the one handle may be given to them because their application may not be accepted online. So they may be given liberty to submit it physically, hard copy,
To apply offline application.
offline.
Offline application.
Maybe.
Stop. In the meantime, this matter for admission, after 8 weeks, in the meantime, the appellants or the respondent state are free to move appropriate application before the learned single judge for final disposal of the writ petition.
But this matter may be disposed of, you know, because this matter may be disposed. No, Rafiq,
Yes, sir, that's right.
That is, but for that I cannot give the concession lordship.
No concession. nahi hai.
Because if lordship allows them, that will send a wrong message to the learned single judge. I'm using a wrong word, lordship. That will give a handle to the learned single judge. Or maybe any observations of course, there is no observations also. But the thing is that
Okay,
whatever my learned,
pending. We'll see to it.
both have
Next.
create some confusion.
Offline application, if submitted before the last date.
That is well.
Ultimately, lordship's decision will be final in this case. Because
why did we have this?
because the learned senior counsel's opening statement was that it was amounting to final disposal of the writ petition. I fully agree to that.
You agree to that?
Yes, Lord.
Then what remains?
Nothing will remain thereafter.
Okay, we'll see to it.
Lordship.
Obliged, my lord.
Daily list for hearing item 30.
Highly obliged.
Second also same order.
Item 33, my lord, same order would be.
33 and 34.
34, my lord, same order would be.
Same order.
We are highly obliged, my lord.
Sir, due to some time constraint, hearing may not be possible.
Look, there is some, this man is retiring. Can I pray for an early date, my lord?
No date.
Yes.
What are we?
Mangalore visit business can be.
Whatever the date, is there price, please.
But yes. From yeah, yeah. Nobody, nobody. If I hold over, you should decide that.
ये पहले इसको मैं बोलने था आपके
तो वही है,